Welcome to the Data Street, the podcast that dives deep into the fast-moving currents of data, technology, and the law. BakerHostetler's Digital Assets and Data Management Practice Group, DADM, brings you this series, hosted by partners David Sherman and Nichole Sterling, to explore how companies navigate the complex and often intertwined lifecycle of data, from privacy and cybersecurity to advertising, AI, and other emerging technologies. I'm Charlie May, and you're listening to Baker Hosts. On today's episode, David and Nichole speak with Rob Musiala, a partner in our Chicago office who co-leads BakerHostetler's Web3 and digital assets team. Rob has experience in digital assets, focusing on regulatory compliance, investigations, and technical architecture design, including as a patented inventor.
Hi, Rob. It's great that you had an opportunity to join us today. You have been active in the blockchain and digital asset space for many years. What initially drew you to this field, and what is it? It's a bit of a mystery field for a lot of people. And how would you say that this digital asset space has evolved over the past decade or so?
Thanks for having me on the show, Nichole and David. For me, I fell into the digital asset space early, partially on accident and partially through my own interest. I was working as a financial crimes investigator back in 2012, and I had an investigation that led to Bitcoin, and that was very early days for Bitcoin. There wasn't much publicly posted about it other than the Bitcoin white paper. And in that investigation, I was asked to figure out what Bitcoin was and how it fit into what we were looking into at that time. And I did a bunch of research and immediately became fascinated with this concept and recognized that it was much more than a financial tool, but there was an entire new technology underlying it called blockchain. And from there went on to do a lot of interesting work in both the financial crimes area and in the solution building area, and realized that blockchain could be used for all sorts of things. And in those days, I became an inventor on a patent that was filed in 2016, granted a couple years later. And that's where it all began for me. In terms of how the space has evolved over the past decade, it has moved lightning fast. A decade ago, there was Bitcoin and Bitcoin alone. A couple years after that, we had the Ethereum network launch. And since then, there have been a number of what are called layer 2 networks launched on top of the Ethereum network, in addition to many, many other independent blockchain networks that we won't get into today. And all sorts of new products that have been launched as a result of the ever-evolving underlying technology, including things like NFTs, meme coins, various types of financial assets, and various types of non-financial assets related around things like data encryption and secure data transfer. So the industry has evolved very quickly from the early days when it was Bitcoin and Bitcoin alone into an entire industry that really is fast becoming a part of the mainstream financial system and mainstream data management ecosystem.
So, Rob, as co-leader of BakerHostetler's Web3 and digital assets team, could you explain what is Web3 and what are some of the most pressing legal challenges that you and your clients face today in the Web3 ecosystem, building on that evolution that you just described?
Sure. First of all, what is Web3? Well, Web 1 is generally thought of as the first iteration of the internet, thought of as a read-only internet where some third party is publishing information that you, the user, can read and view. Web 2 generally is thought of as an internet where different users are able to interact with each other. And that can take the form of financial transactions, where David, me and you are transacting with each other, or it could take the form of messaging and information sharing, where David and I are sharing information and thoughts directly with each other through the internet. But with Web 2, all of those transactions are taking place, first of all, not with unique sets of data, but rather copies of data. We're all used to copying and pasting things and saving things in different places. And Web 2 is by and large the internet of copies of data. Similarly, in Web 2, we're working not directly with each other, but we're working through third-party intermediaries. Every transaction that occurs in the Web 2 world, the traditional web world that we're familiar with, is being managed by a third party typically. So with Web 3, we are working not with copies of data, but rather with an original piece of data. The example I like to give is if you think about email. So David, if I send you an email and I attach a file to that email, when I hit the send button, you have the file, but I still have the file in my sent box. And now there's a third party that has that file, whatever third party managed that email server. Well, imagine a situation where when I get on email and I attach a file and I hit send, David, now you have the file and you're the only person that has it. I don't have it anymore, and there's no third party intermediary that has the file. That's kind of how Web3 works when it's working right, where we are dealing with the original set of data, not a copy, and where we're working in a world where users are directly interacting with each other without an intermediary. And that's all enabled through blockchain technology, which applies various concepts that have actually been around for a long time, including things like distributed networks, advanced public-private key cryptography, and data immutability through a process called hashing. And we won't get into all the technical details there. But by applying all those different concepts in a novel way, blockchain enables these transactions in a web where we're dealing with originals, not copies, and we're dealing directly with each other as opposed to working through intermediaries. In terms of some of the legal challenges, we could do a whole podcast episode on that, but very briefly, just like in any tech field, but I would say this concept is magnified in the Web3 world. We're dealing with technology that is evolving very, very quickly on a daily basis, and a legal landscape that is at worst not changing, so very slow to keep up, and even at best, still not able to move fast enough to keep up with the evolving technology and the evolving business models. And on top of that, a legal landscape that varies drastically across different jurisdictions across the globe. And so in general, the challenge is keeping up with a technology market that moves very fast while dealing with a legal environment with rules that were crafted, for the Web 2 world and that aren't necessarily fit for purpose for this new technology.
So I'm going to jump in with the next question before David takes us down the rabbit hole of hashing, which I know how much he loves. I find your background as an investigator quite fascinating, Rob. So I know you've led investigations into crypto fraud, crypto exchange hacks, NFT phishing schemes. Could you walk us through some of the challenges in investigating digital assets and how you overcome those?
Sure. Investigating digital assets is a combination of applying traditional investigative techniques with entirely new techniques that are all a part of this new technology. So from a traditional standpoint, you've got to be good at all the things that a traditional financial investigation requires, including things like interviewing witnesses, gathering and sorting through documents and data, identifying what's relevant, removing what's not relevant, piecing a story together with disparate facts from disparate sources. All that stuff is very important. But then you've got this additional layer of cryptocurrencies and the blockchain, where digital assets on a blockchain are transferred in what is commonly referred to as a pseudonymous fashion, in which you can see the amount and day and time that a digital asset moved, and you can see the public key that transferred it and the public key that received it, but you don't know who's behind those public keys, which are just unique strings of letters and numbers. There are now very advanced tools that help to, in a lot of instances, streamline the tracing of digital assets on a blockchain, and in some cases actually de-identify the parties behind those pseudo-anonymous public keys. And those tools are very helpful, but they don't solve the whole problem, because before the tools can really be helpful, you've got to identify the public keys that are relevant to your investigation. So in other words, you've got to identify the origin points for the tracing of digital assets that you're looking to accomplish. And identifying a public key in a massive set of data that has been, that you have taken custody of in an investigation is a challenge in and of itself. Fortunately, at Baker, we are very, very good at slicing and dicing and sorting through data, especially large volumes of data. I like to think we do it better than anybody else. And so we've developed our own methodologies for performing that review of data in a way that optimizes the ability to identify the right public keys that you're looking for in an investigation. Once you have those public keys, you can apply the tools, and getting the right tool and using the right tool is important because each tool there are a variety of different tools in the marketplace and each has their own unique advantages. And so understanding what the different vendors can do and can't do and where some excel over the others in different areas is important. And so you have your public keys, you apply your blockchain analytics tool, and that's where your tracing begins. But then where does it end? It usually ends in really 3 different places. The first would be a third-party platform. And in those cases, you face the challenge of negotiating across the table from that third party to try to obtain the data that you need from them to continue your investigation. In other instances, in this Web3 world that we just talked about, the end of the tracing leaves you at a wallet that is not controlled by a third party, but some individual, also called an unhosted wallet. And the challenge there is identifying who owns the private keys to that wallet and the ability to access that value. In other cases, your tracing ends at a smart contract or DeFi protocol where your digital assets are actually locked up, so to speak, in a smart contract for various functions, including things like earning interest or participating in some kind of decentralized financial investment. And there the challenge becomes understanding how that DeFi platform works and unwinding that investment in order to take custody of the digital assets. And this, in a lot of cases, takes us back to that initial concept of sorting through data, because in order to perform that last step, you have to have the private keys. So sometimes that means identifying where in your data lake those private keys might be residing and taking steps to identify and take custody of those. Other times it means being across the table from a legal perspective from a third party, whether that's an individual or an institution that may have access to that private key, and figuring out how to work with that third party to demonstrate that the assets are yours, not someone else's, and take custody of them. And then finally, once you've taken custody of the assets, figuring out where to custody them and how to liquidate them in the most responsible manner. And then in the event that you end up in litigation, finding the right expert that can explain all of that to a court, both verbally and in written reports. So those are some of the challenges in a nutshell.
So just building on that for a minute, you've clearly worked on blockchain-based systems across the board, but let's focus for a moment on, for instance, public fund management and P2P micropayments. How do you balance innovation with regulatory compliance in these technical architectures?
Well, so the 2 topics you referred to, public fund management and peer-to-peer micropayments, are 2 of my favorite subjects because they're the subjects of the 2 patents on which I'm an inventor. And so these are related to ideas that I've dreamed up in this space. But I'll speak to sort of solution building generally and how to balance innovation with regulatory compliance. And really what it comes down to is working with the tech teams from the very beginning is key. And what I'd like to think I've been able to do effectively, and I think part of this is a result of going through the process of building my own solutions through the 2 patents that I invented, I'd like to think I'm pretty good at thinking through that design phase and thinking it through from a technical perspective, not necessarily a legal perspective, as well as thinking it through from a business perspective, and then communicating with those tech folks and with those business folks to understand what they're looking to accomplish, and then explaining to them in language that they understand what the legal requirements and legal hurdles might be. And through that process, by creating that dialogue amongst the legal folks, the business folks, and the tech folks especially even the coders, that dialogue is what allows you to overcome those challenges, because you've got to be able to explain the legal and regulatory compliance challenges to the tech folks and the business folks in language that they understand, and help them to come up with ideas in an iterative process to figure out how to get to their end goal. And sometimes that means altering the technical architecture slightly in ways that, if it's working correctly, don't really matter much to the business, but matter a lot from a legal and compliance standpoint.
So looking at blockchain from a slightly different perspective in terms of use case and balancing, again, innovation versus risk. Let's say, again, I know you have experience advising the national security community. How do you view national security implications for blockchain adoption? Again, this amazing, not new technology at this point, but again, technology, particularly, for instance, in cross-border transactions.
From an illicit finance standpoint, I like to highlight a couple key aspects of digital assets and blockchain that create unique challenges. The first is this concept of a very fast peer-to-peer payment. So we talked about transactions where there's no third party in between the payment. It's direct peer-to-peer. And that's a very new and novel thing. And there are a lot of great benefits to that. But from an illicit finance standpoint, it sort of changes the game, because there's no third party that can block a transaction. And transactions clear very fast and cannot be reversed. And so what you have there is, underlying those transactions, you've got things like the Bitcoin network, the Ethereum network, and other blockchain networks, which are effectively censorship resistant. You can't go out there and seize a server and take down the network. That's from a practical standpoint, that's impossible. And so you've got, number one, these fast peer-to-peer payments. Number two, those payments are taking place on censorship resistant networks. Those are two of the main challenges that digital assets and blockchain create from a national security standpoint. Then you've got some other unique aspects that can be challenges, but also can help be part of the solution. One of those is the fact that blockchains are effectively public transaction ledgers. And we just talked about tracing crypto transactions a minute ago. And so the beauty of a blockchain is the data is all public, the transactions are all public, and crypto transactions can be traced. And in a lot of instances, they can be traced to points where the illicit actor is looking to convert the digital asset into fiat currency. And that's usually done through a third-party conversion platform, cryptocurrency exchange or another platform. And the advantage there is that some of those platforms will be friendly to law enforcement, can be subpoenaed, and will provide relevant information. On the flip side, some of those platforms are operating in jurisdictions where they are not cooperating with law enforcement and won't provide that information. And then finally, another challenge and growing challenge is decentralized finance, where that conversion can take place more and more often, not through a third-party exchange platform, but rather through the decentralized finance ecosystem, which can pose its own unique challenges.
So I'm going to jump in and shift a little bit to thinking about agreements and how you draft and negotiate agreements across NFTs, custody, mining, etc. What trends are you seeing about how these contracts are evolving as the industry matures?
I've represented transactions where I'm on the side of an institution across the table from a Web3 startup. And then I've also represented the Web3 startup across the table from the institution. Generally, what I've seen is when you're on the institution side, the Web3 startup is oftentimes providing a unique service that the institution cannot build itself and needs to use this startup vendor for, and a service where that is important to the institution. But at the same time, it's a service that the institution is not familiar with offering, and maybe is not even familiar with all of the technical nuances of what is being offered by the startup. And the startup often has, in a lot of cases, has a contract that they've used with other startups or smaller companies that maybe don't give an agreement the same level of scrutiny as a large institution would give. And you see this contract, and from the institution's standpoint, it's just a non-starter, and it's got to be rewritten and done over. And you've got to really add a lot to it and revise a lot to get the institution comfortable with that. And so there are a lot of challenges there. One is getting that startup comfortable with the process, that, they're not transacting with another startup or just a small business. They're now transacting with a large company that just does business in a different way and has a different risk profile. And so we can't use the same 1 or 2 page agreement that you've been using. We've got to have something more robust. From the perspective of the startup, across the table from the institution, a lot of times the institution doesn't understand or have an appreciation for some of the unique aspects of the technology being offered. And a lot of times the institution tries to fit the startup into sort of the larger bucket of technology vendors that it's been dealing with. And so sometimes tries to include terms in a contract that just don't make a whole lot of sense. And so there the challenge is convincing the institution that some clauses that they've maybe used in other with technology vendors are unnecessary. And then in some cases, there are clauses that need to be added to account for technology that the institution maybe isn't so familiar with. And some of these areas relate to things like security risks, regulatory compliance risks, control over various aspects of a certain solution, access to data, intellectual property rights, and then even some of the more terms in an agreement that are often viewed as standard, things like indemnification, limitation of liability, termination. All of those areas typically need to be updated from the perspective of either the startup tech vendor or the institutional client. And you've got to do so in a way that is acceptable to the other side. So there's a lot of negotiation and explanation and compromise that often has to happen.
So it sounds generally like you're dealing with a lot of education on sort of all sides of these agreements when you're dealing with them. And I do like what you say about access to data, because as the privacy attorney on this podcast, I always appreciate those considerations. Looking at the types of considerations that we do get around sort of things like privacy and consumer protections, what do you think about when you're designing smart contracts and decentralized applications?
That also could be the subject of an entire podcast, but I'll answer it relatively briefly by kind of hitting the highlights here. First, in any decentralized application, you fundamentally begin either post-launch or shortly after launch at a standpoint where you do have a degree of centralized control. And so one of the key considerations is, what is your path toward true decentralization in whatever application you're talking about? And having a roadmap and clear plan for how to reach that decentralization in a way that manages risks and meets your goals is really key. One critical aspect of that is the moment at which, in a smart contract, the developer relinquishes what's colloquially called the kill switch, which is essentially the ability to alter that smart contract. So at a certain point along the way in developing a smart contract application, generally you will release and relinquish control over that smart contract. And so a critical timing point and decision point is when that step will occur. And there are other steps along the decentralization path that are important. Things like, to the extent that the application is managed by a DAO, a decentralized autonomous organization, how and when does the ability to exercise control over that DAO, how and when does that become decentralized enough, spread out enough across various independent parties to where you really reach kind of a threshold of decentralization? And then the last thing I'll just mention is, it's important to understand and think through what the intended use of your DApp is, and to think through what some of the potential unintended consequences of it might be, and to plan for those, especially before you pass some of those thresholds that you can't go back on, things like relinquishing the kill switch.
What legal or regulatory developments do you think over the next 3 to 5 years are most likely going to, or most significantly going to shape the future of digital assets and Web3?
Well, that's a great question for today because here in the US, we will have the Genius Act signed into law. And the Genius Act is the first major piece of digital asset legislation here in the United States, and it creates a regulated framework for stablecoin issuers. A stablecoin is a digital asset where each digital asset is backed one-to-one by a US dollar equivalent, custodied by a US bank, and typically audited by a US public accounting firm. And these stablecoins, also called fiat-backed stablecoins. There are a lot of different types of stablecoins, but these are fiat-backed stablecoins, will now be regulated under the Genius Act in a piece of legislation that, while not perfect, is very, very good and will allow stablecoins to become a more mainstream aspect of the financial system and of the global e-commerce system. And that's very likely the most significant regulatory development that we've had as of yet in the digital asset space. So that's very exciting.
I will then go on to our final question. So as we wrap up today, we want to give you the opportunity to tell us something that you would tell every in-house counsel to pay attention to right now.
First, I would say this industry is not going away. It's only going to become more and more part of the mainstream financial system, the mainstream data management system, the mainstream e-commerce system. And so it's important for any in-house counsel to think about, where does this affect my business now? Where will it affect my business 2, 3, 4, 5 years into the future? The other thing I'll mention is that on the immediate horizon, some of the products or concepts to pay attention to are exchange-traded products, crypto exchange-traded products that are now listed on public securities markets, stablecoins, which we just mentioned, which will fundamentally change the nature of e-commerce and which will very likely begin to integrate so-called decentralized finance into the traditional finance system. So those lines will start to blur with stablecoins becoming regulated under the Genius Act. And then with regard to public companies, a new trend is public companies that are holding Bitcoin on their balance sheet as a treasury asset, and more companies are considering that. So those are some of the immediate trends to look for. But in general, this technology and the digital assets space will touch just about any business in some way, shape, or form. And it's important to understand where those touch points are with your business and keep an eye on the changes in the technology, the marketplace, and the legal landscape so that you're prepared for how to handle those.
Rob, this was absolutely fascinating, and I learned so much. Thanks again for taking the time to discuss with us and carving out part of your day. We really appreciate it.
Thanks, Rob.
Thanks for having me on the show.
If you have any questions for David or Nichole, their contact information is in the show notes. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of the participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.